gonna kill you if I use that. You'll all sue me for noise pollution.
Give it time.
My voice is pretty big. I used to get pounded by all my brothers and sisters because my voice was so obnoxiously loud.
We'll find out.
So, let's go to the carriage house here.
Carriage house, probably, let's see, that first.
Hey, I'm one of those attorneys that everybody talks about and likes to kick like the family dog. And I've come here today to follow up. I didn't, there was no collaboration with Mr. Sovak and myself, but it was great hearing his talk because I think there's a lot of parallels between the two. What I'm basically going to talk to you real quick today, as quickly as I possibly can, is about whether towns have the authority to pass these bans and moratoriums. And I apologize for anybody in the room that's seen me in other places because it's been discussed at different town board meetings and stuff. I'm going to try to do it a little bit quicker today. Could you go ahead and move through? So what we're going to do today is we're going to discuss whether New York towns, local towns, have the legal right to place moratoriums. And I'm going to include in that term moratoriums and bans. We're going to speak generally. Moratoriums on oil and gas activities. Next, we're going to talk about, I'm not sure if I'm even going to go into this part, but we might. What are the possible benefits and risks to your town passing a moratorium? All right, next. In order to do this, we need to look at basically three areas of law, three legal principles. The first is home rule. Then we're going to talk about express preemption, and then we're talking about implied or conflict preemption. Okay? Now, home rule, what is home rule? Well, the New York State Constitution has what we call a home rule provision. And it basically, in the Constitution, it says that this home rule power confers broad police power upon local government relating to the welfare of its citizens. Now, this grant of authority includes the ability of a municipality to enact local laws regarding the protection, get my new little pointer here, protection, order, conduct, safety, health, and well-being of persons or property within its borders. So as we can tell from that language, this home rule power is pretty expansive. But there are limits. You know, the state never gives, the federal government never gives the state, nor does the state give towns unbridled authority to regulate us or our property. One of the key limitations here is within its borders. This is going to be huge because we know if one town passes a ban or moratorium, if that ban or moratorium impacts another town, then we got some major issues. And we're seeing this now with the county governments, where their findings on review of some of these proposed moratorium and bans, they're saying that, well, we need to have a supermajority here because of intergovernmental conflicts. They're seeing that there's going to be huge potential for towns suing towns, and one town's actions impacting another town. So, right up, the first slide, right off the bat, we see it has to be limited to your jurisdiction. Well, when you read half of the bans and moratoriums that have been put in place in New York, that first thing has been blown out of the water already. Okay. Like I said, you know, municipalities generally, if an area of our lives or our property is not regulated by the federal government or the state government, then towns are allowed to regulate it if they see that there's a necessity there. But, as I said, it's not unlimited. Under the doctrine of preemption, basically says that a local government may not exercise its police power by adapting a local law that's inconsistent with the Constitution or general law. And when it says constitutional law, it refers to both the New York and federal law. So now we're being told that if it conflicts with New York law or federal New York State or federal constitutional law, that's problematic. And in addition, if it conflicts with any general law of the state of New York, that's problematic. And preemption can be express or implied. In other words, we can look at the statute, look at its wording, the express words, and determine whether there's preemption. And also we can look at the regulatory framework, the policy behind the law, to see if there's any implied conflict. So those are the two. You can go to the next slide. Now, as most of us know in this room, we have a section in New York State law called the Environmental Conservation Law. Specifically, Article 23 reserves to the state the authority to regulate oil and gas drilling and development. All right, so this isn't an area where New York State has been silent. They've got a law on the books regulating oil and gas law. Article 23, we'll see when we read its preemptive provision, does not give a town any authority to enact or adopt local laws to regulate or prohibit gas drilling. The only two areas of law that have been exempted out of its preemption have been roads and taxes, and we'll see that. Let's move on to the next one, please. The New York courts have, and this issue has already been addressed in New York. You know, if you go to a lot of the advocates of the moratoriums and bans, they failed to bring up the one case that was decided in New York on the preemptive provision in the Oil and Gas Solution Mining Act. And that case is Envirogas. The New York courts have already addressed the meaning of the preemptive provision in the Environmental Conservation Act. In Envirogas Incorporated v. Town of Keatone, the New York State Supreme Court, it's the lowest court in New York, just like the Dryden and Middlefield decisions were, invalidated the town's own zoning ordinances due to the preemptive provision in ECL, the Environmental Conservation Law. Next. This is the actual provision. The express preemption provision of the Environmental Conservation Law states that the provisions of this article shall supersede all local laws or ordinances relating to the regulation of the oil and gas and solution mining industries, but shall not supersede local government jurisdiction over local roads or real property tax. So it basically says that this statute is going to preempt any local law unless it relates to two things, roads and taxes. It only left two pieces on the table. Everything else the state took in its control. Another thing that is interesting in that, can we go back to that previous one? You'll see, we're going to look at the preemptive language in the mine land reclamation law, because the environmentalists like, or the advocates of bans and moratoriums like to cite it. But you're going to see one big difference. In this provision here, you need to go back. These two words right here. It says the provisions of this article. Now realize, when you look at the Environmental Conservation Law, you have article, that's the name of the entire law, and then you have subsections or titles. This refers to the article. This controls the entire article. Remember that. It'll become important later. And this is not a point that has been brought up in any of the cases thus far, in the Middlefield decision or the Dryden case, and it's huge. Next. In reaching its decision in the Envirogas case, this is what the court said. The mere fact that a state regulates a certain area of business does not automatically preempt all local legislation which applies to that enterprise. But where the state law expressly states that its purpose is to supersede all local ordinance, then the local government is precluded from legislating on the same subject matter unless it has received clear and explicit authority to the contrary. So, for example, in the Oil and Gas Solution Mining Act, it specifically said that we're gonna supersede everything but roads and taxes. So it's pretty clear. The court found that the environmental conservation law preemption language preempts not only inconsistent local law, but also any municipal law which purports to regulate gas and oil well drilling operations, unless the law relates to local roads and real property taxes which are specifically excluded. That's what we just said. Accordingly, precludes any regulation of oil and gas industry at the local level, including zoning regulation based on public health, safety, and welfare. Next. The advocates of the moratoriums dismiss this case. They basically, most of them don't even bring up the EnviroGas case. So they just blow it off, and they say that it may be not, and one of the reasons why they give for justification for blowing it off is they say, well, it's not controlling precedent. It's just one little low court telling the rest of the state what it determines to be the law, but because we are other little lower courts, we don't have to listen to them. Well, it's basically the same argument that most of us are saying about the Dryden and Middlefield case. We really don't. It's not controlling precedent on anybody else outside of that jurisdiction. But what is interesting, though, is this case was appealed to the appellate court. And the appellate court said, no thanks, we don't want to hear it. Now typically when an appellate court says, no, we're not going to hear it, it's because they agree with it, typically. If there's not an issue, they don't see an issue with the decision is well reasoned and decided, then the appellate court doesn't have to take it, and it basically says, no, we're fine with that. So sometimes the court's inactivity at the appellate level sends huge messages to what they're thinking on the question of law is. Next. Now the advocates of the local zoning authority want to ignore EnviroGas, and they look instead at case law under a separate environmental conservation law Title 17 or 27, which concerns surface mining. So basically they say, well, yeah, we got an environmental gas case over here that specifically discusses oil and gas, the oil and gas and solution mining industry, preemptive language, but don't worry about that. Look over here, we'll look at this mine land reclamation law. And let's see what the courts have decided on that. And they cite specifically two cases, Brew Run Gravel and the Granite Asphalt products. They state that these decisions support local government's right to use zoning laws to regulate oil and gas industry. Now, in Brew Run, the Court of Appeals upheld the town's decision to prohibit extractive mining in a zoning district. And at the time, the preemptive language in that title stated this: for the purposes stated herein, this title. This is key again, remember, because this now it's saying just this section of the article. Just this section, not the entire article like the last one said. This title shall supersede all other state and local laws relating to the extractive mining industry, provided, however, that nothing in this title shall be construed to prevent any local government from enacting local zoning ordinances or other local laws which impose stricter mine land reclamation standards or requirements than those found in it. So here in the Oil and Gas Solution Mining Act, it said it precluded everything but roads and taxes. This one, no wonder they cite to this. The provision, the superseding provision specifically allows local zoning. The express words in the title allow it. Next. Therefore, for mining, the legislature explicitly preserved a town's right to zone out sand and gravel mining under Title 27. It gave them the right. The preemptive provision governing the oil and gas activity provides no such exception. The only exceptions relate to roads and real property taxes. So ask yourself, if the legislature was so clear with sand and gravel mining, why, if the legislature wanted to give towns the right to prohibit gas drilling, why didn't the legislature provide similar language in the oil and gas drilling section? Or why didn't they just say in the article superseding provision that they could? Roads, taxes, and zoning. That applied to the whole article. That would have been an easy solution, but they didn't. Typically, the legislature doesn't do things for a reason. So when we look at the expressed actual words of the statute, the first step, we see that the words vary from the Oil and Gas Solution Mining Act versus the Land Reclamation Act. The preemptive provision of Article 23, the Oil, Gas, and Solution Mining Law, accepts only regulations of roads and local taxation. In the Mine Land Reclamation Law, it exempts local zoning ordinance or other local laws which impose stricter mine land reclamation standards. So one allows it, the other one doesn't. Next. Now that's just the first part. All right, so when we have a law there's gray area, the first thing we do is we look at the explicit language, express preemption. But even if a court were to find, that's a little confusing, we're not sure what they meant by that, which I don't think is the case, but maybe somebody would. Then the next thing we look at is what we call implied preemption. Okay, let's look to see what requirements, details, regulations they have in place to see if we can infer a want or an intent to preempt local municipalities. Local courts still do find local municipalities do not have the authority to regulate oil and gas industry based on implied preemption. All right, in New York State Club Association, the Court of Appeals has explained this implied preemption issue. The legislative intent to preempt need not be expressed and need not be in writing. It is enough that the legislature has impliedly evidenced its desire to do so, and that desire may be inferred from one of two things. The declaration of state policy, which is typically in the statute itself, or from the legislature's enactment of a comprehensive and detailed regulatory scheme. All right, now we're going to look at those two things and see if we can see some implied intent to preempt there. Next. This is the declaration of policy in the Act. It is hereby declared to be in the public interest to regulate the development, production, and unitization of natural resources of oil and gas in this state, in such a manner as will prevent waste, to authorize and to provide for the operation and development of oil and gas properties, in such a manner that a greater ultimate recovery of oil and gas may be had, and that the correlative rights of all owners and the rights of all persons, including landowners, and the general public may be fully protected. Okay, so that's the policy. Next slide, please. As stated, it is the policy of the state to regulate the development, production, and utilization, and to authorize and to provide for the operation and development of oil and gas properties. That's what the stated policy is. Therefore, it is the state's policy to facilitate gas development, not to prohibit it. So how in the world can a town ban or placing a moratorium on oil and gas activities within their jurisdiction not frustrate or conflict with that stated policy? It's impossible, in my opinion. We need to go back. Sorry. So I just don't get it. So the first time we look at the implied preemption of stated policy, we got major problems already. All right, next. Unlike a through run where the court determined that local zoning authority would not conflict or frustrate the state policy and statute's purpose in the Mine Land Reclamation Law, The same cannot be said for the oil, gas, and solution mining law, which purpose includes preventing waste, providing for the greater ultimate recovery of oil and gas, and protecting correlative rights. The reason for the ECL's broad preemptive relative to oil and gas drilling is based on the fact that decisions about where drilling units are formed must be decided on the geology. These decisions should not be based on a patchwork of inconsistent and perhaps politically driven local land use policies. So, I mean, the whole reason why we're drilling is based on the geology. And oil and gas, in its geology, is different than a geology based on surface mining. I've never seen a surface sand or gravel deposit move. Even after a long night around the campfire, drinking a few Jennings, I've never seen a sand and gravel deposit move. Oil and gas, it does, all the time. It is clear that the legislator intended to show that it intended to cramp local regulation by the enactment of a comprehensive and detailed regulatory scheme. So in addition, when we start looking at the detailed regulatory scheme that they put in place to regulate oil and gas, we see this further buttresses the whole argument that they meant to preempt. Allowing individual towns to ban oil and gas activities would directly conflict with and frustrate these statutory regulations that detail statewide unitization, spacing requirements, and compulsory integration that have been in place for years. All these things that have been in place for years in New York State would be turned upside down. The oil and gas law in New York State would be turned upside down if towns were allowed to place bans and moratoriums based on political whim, on political jurisdictions, on boards being elected every 2 years. What are we going to have one town board come in and put in a ban or moratorium? Then 2 years later, a pro board gets in and they say, no, we're going to take that ban out. Then 2 years later, it comes back in. I mean, that's no certainty. You couldn't run a chemical factory. You couldn't produce milk in the state of New York if the powers that be changed their mind that rapidly. Allowing individual towns to ban oil and gas activities would directly conflict and frustrate these statutory regulations that have all these details. The environmental conservation law contains exacting requirements concerning location and size of spacing units and the location of well pads. So why do we have this comprehensive regulatory scheme? Because well siting should be based upon geology and the fact that oil and gas migrates and does not respect municipal boundaries or, for that matter, zoning districts. Next. If the courts now, so basically we've looked at this. We've seen the first home rule says that if you do have the power, you have to make sure that your proposed law regulates only within your jurisdiction. They failed at that. Then we look at express preemption. Well, it's pretty clear for me, looking at the two different provisions, it's one gave them the right to zone things out, the other one didn't. But even if we ignore that, we look at implied preemption. We can imply it from the state policy, and we can imply it from the comprehensive legislative scheme. But let's say we still don't agree with it. If we now know that the Dryden and the Middlefield cases have been appealed, or are going to be appealed, we just found out a day or two ago. If the appellate court upholds those decisions, we're going to have huge problems. We're not going to solve any problems. There's no winners. These towns aren't going to be winners because their bans or moratoriums can be left in place. It's going to create bigger issues. Landowners with land in 2 jurisdictions. Can he or she drill under town with a ban? Let's say we have a landowner's 500 acres, half of his land's in Oneonta, half of his land in Otsego. Can he, what happens there? He could drill half of his property? Just because they have bans or moratoriums in Oneonta, how about if he wants to drill underneath them? Ban and moratorium zoning usually applies to the surface, does it not? Not to the subsurface. You know, these bans and moratoriums place bans on pipelines. Well, as we heard, FERC regulates interstate pipelines. How can Oneonta tell the Federal Energy Regulatory Commission that it can't put a pipeline through? Sorry guys, I don't think Oneonta is going to be, you know, elbowing the federal government. You know, I mean, there's issue upon issue. It's going to get ugly. You know all these lawyers you guys hate? Well, you're going to be inundated with them. And all your tax monies that you pay in are going to be going to the suits. Or we can do some oil and gas development, and then I can make money being a geologist. I prefer to do that. What happens if one town ban inhibits pipelines? Two town bans require supermajority. Then we're going to start getting into the county, like we're seeing. Delaware County, Otsego County saying, whoa, 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 whoa. Sydney wants what? No. Sydney passes a moratorium and ban, they trump it. They say no. Because they're starting to see what these issues would be. Next. All right, as we all know, recent lower court decisions in both the Dryden and Middlefield cases upheld the town's power to ban all oil and gas activities in their jurisdiction. This was a lower court case, not, you know, it is what it is. And it's likely that these are going to be appealed. Not only is it likely, it is, they have been appealed. As we stated, you know, whenever a lawyer typically gets up in front of a room, it's not a question of white and black. We make money on gray. The only time when you need a lawyer is when there's gray. People, you know, say, Ed, you know, we hate lawyers. Well, if you hate lawyers, then elect people that can write laws. Not people that propose home rule legislation.
But the legislators are lawyers.
But people, a lot of them are. Pick the geologist and the lawyer. And just do this. If you elect one of them and they can't write a law, get rid of them the next term. I mean, the power to get rid of elected officials, dude, it's underutilized in our society. You know, the bottom line here is that regardless of how this shakes out, this whole, you know, I mean, I look at it and I say, at the end of the day, regardless of what the state appellate courts or the highest court say on this preemption issue, if they don't get a time to answer the question, home rule, there's bills proposed in our legislature right now that would give them the power. If Senator Seward's proposed home rule law is passed, these cases are going to be moved because the law will have changed. They won't have to determine what the old law said. That home rule legislation will give the towns right to zone it. And it's interesting because when we look at other areas of the country, our competitors, Ohio, Pennsylvania, West Virginia, guess what they've done? West Virginia's Supreme Court said, in very similar language, said, no, it was clear that the state preempted local zoning. Done. Towns are precluded from regulating oil and gas in West Virginia. Pennsylvania. The case actually was decided by the Pennsylvania Supreme Court, came down in favor of the towns, allowing them to place bans and moratoriums. Guess what the legislature did the next term? Changed the law, prohibiting towns. Ohio. Court case found that clearly preempted. So all our competitor states, you know, the ones that have jobs, that have people that are making 70 or 80 grand a year, that are, you know, now have budget surpluses, those guys, they've done the exact opposite of what New York is doing right now. You know, we've already given our competitors a 300 lap lead in a 500-mile lap race. It's time to stop the foolishness. It's time to support Jennifer Huntington's lawsuit. It's time to keep doing it for all of you guys. Unless each one of you wanted to pay 70 grand to hire the attorney, then help her out. Let's make it one attorney that makes the money, or one firm, not require, you know, all of the ambulance chasers to come into our county and start making the money on each one of your behalves. You know, we need to put an end to this stuff. We need to move toward oil and gas exploration and development. It can be done safely, and we need to move there for our country, our state, and our local governments, and local towns. That's basically what I have to say. Any questions? Fire away.
As you showed, the ECL article looks very clear, that
Clear as mud.
the supersedes all local government. So what were these judges looking at in this, the Dryden Middlefield case, or what were the losing attorneys going for? I mean, why did they just simply say, this is the article, this is what it says, case closed?
Well, I mean, I think that they probably made the same argument, and for whatever reason, those local judges didn't feel it was that clear. Now, you know, and that, you know, I'm not in the business of bashing other lawyers. It's never a very good thing to do. But who knows? I mean, it's just, you know, these things aren't that, I mean, it's not black and white. But I think when we walk through the legal arguments, when you understand why oil and gas is regulated the way it is because of its geology, you start understanding why this whole thing makes sense and why, when you look at everything, it's pretty clear that the state meant to preempt local municipalities. You know, local judges are the lowest rung in our judicial system. They're the ones that are closest to the communities. They're the ones that are the most political. They're many times they are elected. There's political pressures. As it moves up, those political pressures decrease. Who knows? But I mean, this isn't that slam dunk. But I think that when you look at the totality, it becomes pretty clear. Does that answer your question?
There's another layer that you didn't touch on that definitely will come into play, and that is that once we get to if we get to the pipeline stage, then it becomes Commerce Clause, which is the Constitution, because you cannot, state cannot interfere with commerce.
Yeah, I mean, I think there's a lot of other, I had to limit this talk. But yeah, I mean, there's Fifth Amendment, 14th Amendment. It goes on and on. Federal. And the big one is regulatory taking. I mean, you know, the argument here, and why I think Jennifer's case is a little bit different than the Dryden case, and the reason why I like the fact that Dryden was also appealed, is because I think the Dryden case is a better case for arguing whole taking versus a partial taking. So if we get to that level. But yeah, I normally drag on for about an hour and 15 minutes. Is that it?
What was the specific nature of the zoning ordinance in that EnviroGas case that was, went the other way?
The EnviroGas case had bonding. The town required that the oil and gas company provide a bond for activities, for the drilling activities in its community, and also had a permit fee. And they were like, well, you know, that's definitely regulating oil and gas. All right, now, and that's what a lot of the advocates of moratoriums and me had to argue, even to get back to Deb's, gone through the issue, is that they say, well, when we prohibit all oil and gas drilling in a town, that's not regulating. That's not telling them how. That's telling them where. And that's how they make the differentiation. But to me, that's insane, because we have a statutory scheme that has all sorts of detail on where. And by saying that you can't do it anywhere in a town, you claim to me that that's not regulation. I don't get that.
But that's gonna have to be a fundamental difference.
Yeah, I mean, that's where they hone it.
Thank you very much.
Now, the new strategy, though, is not just to regulate gas and oil. The town of Lawrence has a moratorium that they're proposing, which will ban all business within the town for 1 year. No new growth at all.
Wow,
Town of Lawrence.
yeah, that's interesting. No new
One year
business.
moratorium on all new business and all growth of existing businesses, a 1 year ban.
That's not, that means I couldn't even put my law office in Lawrence. Because I'd be crazy